All right, everyone. Hello and welcome to your 1L Club session on practice essays. Today's going to be a great session. As you see here, we're going to talk about the when, the how, and the why. Practice essays are a huge part of 1L success. It's one of those things that a lot of us either don't know how to do it or sometimes are too afraid to do it, and we end up walking into the exam with nowhere near as much practice as we want to have. But we're here to avoid that. We're going to demystify this whole process of when you do it, how you do it, etc. So let's go ahead and jump into it. So I want to start off with a quote by myself, okay? No shame. This actually, I think, is an amazing quote, and here it is. The majority of practice is for learning and improving. And then my favorite part, duh, okay? And the reason why I really add that duh there is not to be rude or mean, but it's to really emphasize, right, the mindset that you want going into practice exams. So often what I'm doing with 1Ls especially is really trying to shift your mindset that when you sit down and do a practice exam, this is not an opportunity necessarily to test yourself to see if this were an exam, how would you be doing or how would you be performing? And that's often what gives us such anxiety going into a practice exam. Right? We can have finals not for 2 months or 3 months and we sit down and do a practice exam and we're feeling clammy hands, sweaty, nervous, all these things because we're looking at this as an indicator of where I'm at. I want you to shift that mindset and you're looking at these practice exams as an opportunity to learn, right? And the more you do practice exams with that mindset of learning, the more you're getting better, right? One step better every day, and you're actually getting ready for that final exam. Right? And the analogy that you want in your head is that think of the final exam as essentially the actual game, right? Whether it's the championship game or a regular game, whatever. And everything we're doing up until then is practice. And so remember, practice is all about just getting better and learning. So again, all of that in starting this session is start to change that mindset. If when you sit down for practice exams, you naturally get a little nervous or tense or feel as though, right, if you didn't do well, this is going to be, the indicator of how you're going to do in the finals. We want to get away from that. And we want to be excited to do practice essays and always look for every opportunity to master what we just went through in that practice exam. Okay? So let's go ahead and jump in. I want to start off talking about what your overall goal is when it comes to practice essays. The bare minimum goal is to do at least 5 practice essays for each class. So if you're in a part-time program, maybe you're taking 2 doctrinal courses. That's 10 practice essays. If you're taking 4 doctrinal courses, that's 20 practice essays. That's a lot of practice essays, but definitely what you should be doing. What's the ideal goal, right, that I want every student to get to? That's to do a practice essay for every topic you are taught in the class. And so let me explain that. So let's take a class like, let's say, contracts. In contracts, right, in one semester you might learn things like offer, traditional option contract, firm offer, 2207, consideration, statute of frauds, right? And the list goes on. You might learn about 15 different topics, all right? Now, the idea is that when you go into the exam, I don't want you seeing anything really for the first time ever. Now, don't get me wrong. Like, your professor is likely going to throw some curveball at you where there's a variation of something you have seen, so you might have to figure out something on the spot, but you should be familiar with most typical scenarios, so you're not figuring out anything again for that first time in the midst of your final exam. So you want to do one practice essay that has coverage for every single topic, right? When you go to property class, right, if you're on that final exam and you're getting tested on easements, it's like, oh, I've done an easement question before. Here was my flow. Here is my organization on how I did it last time. All right. So again, that ideal goal is with that principle in mind that I want to have seen at least everything once and gotten the muscle memory of writing it out at least once. Now, we might not all reach that goal, at least hit that bare minimum goal of doing 5 total practice essays for each class. Okay. So now we're going to get into right, how to actually practice. And I've spent some years now really perfecting this system. So I want you guys all to take notes as we're going through this. For those that are in the live class, we're going to be able to ask and answer some questions at the end. But this really is a fine-tuned system that's going to force you to do practice essays in a way where you're soaking up the lessons. All right. So it starts off with step one. Read the question. All right, so we're obviously starting with the obvious, that the first thing that you're going to do when you sit down and do that practice essay is read the question. Now, I am starting with this and making this a point because we might not always do this as effectively as we want. So I'm going to give you some tips on how to maximize you reading this question, all right? In the left-hand margin, I want you to write 1 to 2 word summaries of what each paragraph is about. This is going to boost your reading comprehension. And this is essentially going to be annotating your fact pattern. All right, so Deja, we've talked a little bit about essay writing at this point and what a strong analysis looks like. Your analysis should often include what, right? If it's a high scoring analysis.
Facts from the fact
pattern.
Reasoning.
Yeah.
Then applying the rule to those facts.
Exactly. So you have to use verbatim facts. So when we say here, write 1 to 2 word summaries about what each paragraph is about, what you're doing is annotating that fact pattern. So as you know, in about the 15 minutes, when you start writing this out, you're going to have to reference that fact pattern again so you can actually use verbatim facts. Well, if you've annotated that, it's easier to find exactly the fact that you're looking for. All right. And when I say 1 to 2 word summaries, this is really in your own language. This is for yourself just to know what this paragraph is about. If you're doing a contracts, right, essay, first paragraph was, oh, this is where DeAndré met Deja, and that's it, right? And that's just what that first paragraph is about. Next paragraph, oh, DeAndre's offering to sell Deja his iPad, right? And again, you could get shorthand with this and whatever kind of like, you know, abbreviations you want to use and things like that. But that's all you're doing. It's just like, what's this paragraph about? Then in the right margin, as you're reading through, I want you to write in soft triggers. Soft triggers is a term of art that I've used, and it's really to label things that you think are triggered, right? Triggers are something that you'll hear a lot in law school. What's triggered? What rules are triggered? Soft triggers are like, I'm not committing to this just yet, but I think this may be something that's worth a discussion. So let me just get it out of my head and on paper. All right. And you'll put that in the right margins when you see those soft triggers come up. What you're doing by writing these soft triggers down is that you are unloading it from your brain and almost intentionally preventing tunnel vision from only focusing on that issue as you read the rest of the fact pattern. All right, so I always give the analogy here. I'm not sure how many of you have done escape rooms, right? And I really got this concept from doing escape rooms, right? And so the first time I did an escape room, I go into the room and right, you have to like solve these series of puzzles in order to get out. And so what happened was we got in there and I found the first clue, right? And then I put the clue on the table, me and the group put the clue on the table, and then we're just trying to figure out this clue and just like focused on it and just that. And as you can probably guess, we did not get out of the room. It was just like we obsessed over one thing. We didn't see the bigger picture. We didn't see everything. Versus the next time going in, it was just like, okay, clearly some of these things work together. There's a lot more things going on. So what we did was we went in and we surveyed the entire room and got all the clues that we could and then put them on the table. And then all of a sudden, everything started to come together. So it's very much so the same thing with these practice essays and exams in general. You don't want to hyper focus on just the first issue you've seen. You want to find it, put it on the table, right? Write it down as a soft trigger and move on and see how many other triggers you can find. All right, so again, prevent the tunnel vision. When you're reading the question, a few other notes are learn to summarize the fluff as you read. Some things are just background facts, all right? Not every single thing is going to be important, but it might just be helping tell the story. So you want to practice being able to see what is fluff and not important. And then lastly, make sure you read the entire question. I don't know if you've heard the horror stories, but there are the students who have spent all semester reading and briefing, outlining, practice essays. They know the law, they know the rules, but they don't read the entire question. And that last sentence told them a particular instruction, like only discuss under the modern law, but they missed that and only analyzed under the common law, and then now completely botched that exam. So whether it's an important fact or an important instruction, you have to make sure you read through the entire thing. Okay, so that's step one, read the question. All right, as we see, not as simple as we may think, and there's a lot that goes into it. All right, next, step two, stop and think. So this is where I want you to ask yourself, why are the parties upset and what do they want? Now, if you haven't heard me say this yet, right, this is connected also to how you want to learn certain topics as you're going through them, or all topics as you're going through them in your classes. You want to think of every area of law as a solution to some problem, right? It serves some purpose. And you would have heard me say this in other sessions as, what is the function of that rule? All right. Is anybody in here in property class? If so, you can raise your hand.
Yes, I'm in property and contracts.
Okay, perfect. So let's go with property. Have you learned adverse possession yet?
Yes.
Okay, perfect. So my question to you is, what is the purpose of adverse possession, right? We know that has the elements. I'm not talking about the elements, but why does that rule exist? What does it do for a party if all the elements are met?
If all the elements are met in adverse possession, it allows the party to continue to stay on the property that they have been on for, a long period of time, depending on what the statute is.
And not only, Deja, does it allow them to continue to stay on the property, it does.
Oh, it gives them the not the deed, but like
ownership
of the right of possession. That's what it is.
Yeah.
It's
so you get ownership, right? So that is actually the important part of it, Deja, that I want you to be connected to, because then when you have a fact pattern, you can connect the dots there to see if adverse possession makes sense. So Deja, let's say me and you are neighbors. Where do we want to live in this fictitious hypo? What's our dream location to live?
I don't know. I want to go out to Cali where y'all are.
All right, so we in California. We're in Los Angeles, and we're neighbors, okay? We've been neighbors for about 10 years, close friends, and I have too many cars, so for the past 10 years, I've been parking my car in your driveway, right? You've been letting it, you haven't said anything, I never said anything, I just been parking my car in your driveway. Everything has been cool, we're friends. But then one year, right, it was coming up on Thanksgiving, you invited me over for Friendsgiving, and I didn't show up, and you were mad about it, and all of a sudden, you didn't want me parking it in your driveway anymore, in your garage. And so I want to continue to park there. Now, under these facts, right, what is the issue that's being triggered? What area of law are we going to discuss under this scenario? And I guess my question to you specifically is, would adverse possession make sense here?
So, under these facts, I think that adverse possession would be triggered because you said it was over like 10 years that you have been using it.
Mm-hmm. So this is a great learning opportunity, Deja, and so let me connect it for you. So remember a second ago, right, we talked about adverse possession is a tool used to acquire ownership of property, of land. In this fact pattern, am I really trying to claim ownership to your house?
No.
No. What am I really trying to claim? What am I really trying to do? I want to essentially use your property for a limited purpose. I'm not sure if you've covered it yet in your class, but can you think of another property doctrine that actually is a better fit for this discussion? Have you learned easements yet?
I have not learned easements yet.
Okay, so you haven't gotten to easements yet, but that would be the area of law, because when you learn that, it is, right, the ability to use another person's property for the limited purpose. And so in summarizing that whole hypo, the reality there, Deja, is that once you get to learning easements, you'll see that there's some crossover in the elements, right? So you can actually gain possession rights to be able to use, or it's non-possessory rights actually, but you can gain a right to use another person's property through elements that are similar to adverse possession, right? So I gave you the whole thing that like, oh, I was doing it for 10 years. That type of fact typically, makes you think adverse possession. You would write that down as a soft trigger. But then once you get to the end of the question to see that it's simply DeAndré wants to park there, well, that soft trigger for adverse possession is not going to come to fruition and be a hard trigger and be discussed because it doesn't align with what the parties want. Are you getting the point that I'm trying to illustrate?
Yes.
Perfect. So again, the idea here on how to use this, everybody, is pretty simple. Try to focus on what is my trigger for a rule, what is the function of a rule, and how is the rule satisfied for every rule that you learn. And then when you get to the exam and you have this scenario, stop for a second and ask yourself, why are the parties upset? And then what areas of law can solve this problem? All right, that'll really advance your issue spotting skill. All right, now when you're doing practice questions, right, here's some additional things that you should do. Identify novel situations in situations you simply don't know how to handle yet. So for example, if Deja was doing that fact pattern that we just did right now for the very first time, she'd be like, I've never seen a hypo before where somebody was trying to park their car on somebody's land. Like, I wonder how this is going to play out. If you have no idea what something is, right, take note of that. And then really it's like, all right, this is going to be more of a learning opportunity than practice because I'm really just, flabbergasted as to what's going on here. So always look out for novel situations and really make then those something that you're comfortable with. All right. So that's step 2, stop and think. This is just like in real life. Everybody always says, think before you speak. In this case, I want you to think before you write. If you just go from reading the question and then just beelining it into the essay, you might be kind of jumbled. You might talk about issues that aren't actually applicable because you didn't kind of run it through that whole like, what's my call of the question? Why are parties upset kind of thing? And so this is good just to ground you before you start writing. Step 3 is outline your exam. Skeleton only, no rules, no facts. When outlining your exam, this is the last step that you're going to essentially go into before you start writing. And what you're doing here is now writing out all the issues. These are the hard triggers, the things that were soft triggers. And now, after looking at the call of the question and thinking through it, you have determined you will discuss. After you've issue spotted all of the rules you're going to discuss, you want to organize those in a way that's going to flow through an exam. You can't talk about things in just any order that you want. You have to organize it in a way that's acceptable. All right? And then, as we were talking about earlier with Nathan, after you outline, a step that not all take, but is really great to do in your outlining phase, is to take a second to see, where are my prioritized issues within this essay? And just taking a quick pause there to understand the importance. Nathan, ultimately, why do you think it's important to prioritize the issues?
I've realized I just do not have enough time to talk about everything, so you get the most points where the issues are.
Exactly. All issues are not treated equally. The points will be distributed to whatever the more prioritized issues are. And then, Nathan, here's the reality, right? Let's just take your torts example. And so let's say we're analyzing negligence. And then negligence has 4 elements that they can have a really long analysis within it, but let's just like make it big picture. 3, 4. So you could have a situation where, right, this is duty, this is breach.
Yes, you get bored.
Oh, okay, yeah, I'll switch back for you right now. Duty, breach, causation, and damages. All right, let me stop. Okay, so you can have a situation where you have 4 elements like this, and on essay 1 that you do, you could have it where causation happens to be your prioritized issue. Now, if you go into writing this out, you can't start with the prioritized issue. You still have to go through it in the typical organized way. So you have to go through duty, breach. And if you're not in the mindset of these are non-prioritized and this is, you may spend too much time here and not enough time here, and even though you knew everything, you didn't get the right points. Then you could do a whole nother torts essay on negligence, and all of a sudden, breach and duty happen to be the two prioritized issues, and so it could change every single time. So again, this step really helps you figure out where can I spend my limited time on the essay. That is outlining your exam. So next is timing, right? So we've gone through 3 steps now: read, think, and outline. And you want to do all of those in about 15 minutes. Sometimes it's a very short and sweet hypo. Maybe you get it done in 10 to 12 minutes. And sometimes it's a really long fact pattern. Maybe it's multiple pages. And so now you have to maybe spend 20 minutes. I wouldn't ever go over 20 minutes. And again, I think 15 minutes is that sweet spot. But the biggest thing that I do want to emphasize to 1Ls is to not rush through this step. Many times a student getting to that final exam is just so anxious and ready to start writing that they're not prioritizing reading the question to actually know what's going on, right? Thinking through it to make sure they're triggering the right issues, and then outlining that so they have a blueprint for themselves that they can utilize as they're going through. A lot of students will forget that. And what will happen is that you didn't outline, so you didn't create this roadmap that you can look at and use as this like guiding map throughout the hour or 2 hours that you're writing. So if you don't have an outline, you thought of all of what you're going to talk about in the beginning, and then now you're like an hour into writing this out, and you just finished a thick analysis, and then you come up for air and you're like, what do I talk about next? Right? You don't have to have that question and delay if you have that outline that's like, oh, yep, next thing I talk about is this. All right? So 20 minutes or 15 to 20 minutes is, again, that ideal time frame. All right, and again, write down any questions, and we'll be answering those at the end. Let's get to step number 4, right? A lot of what I'm talking about are things you're going to do both in practice and on the actual exam. But this step in particular is specific to just your practice, and that is cross-reference your outline with your sample answer. All right, so as you see here, after you made your outline, we're not going straight into writing. I want you to see if you got all the issues correct. This is how you isolate your issue spotting accuracy and see if you need to make any adjustments. All right, so it says here, once you have written out all the issues you think require discussion, cross-reference your outline with the sample answer or cut sheet to check only issue spotting and organization. What you're looking for are issues that you missed. Sometimes you have extra or unnecessary issues that you included that don't need a discussion. And then sometimes you have misplaced issues. Maybe you talked about damages first when really you should have talked about duty first. And right, so it was a right issue, but just in the wrong place. All right, and so again, do not rush this step. Before you move on from step 4, you must have 100% clarity on what issues were triggered and why. This sequence of actions and reflection is isolating your issue spotting skill. If you cannot issue spot correctly, you cannot do well on the exam. You won't be analyzing the right issues. All right, so before we move on, this is typically the part where students have a little bit of a struggle because there's this stigma that doing a practice exam with the answer or the cut sheet next to you is cheating. And I'm here to tell you that it is not cheating, right? There's ways to misuse a practice essay where you're not trying to do things on your own and you're just looking at it too soon or prematurely. What I just told you to do right now is to try to issue spot on your own and then simply immediately get feedback on that portion of your skill set, right, of issue spotting. So everything on how we use the sample answer, you still have to try it yourself first, but I'm not delaying the part where you get the clarity on how you should have done it. Okay, so that takes us to then the next step. After you've outlined and you've cross-referenced to see how well your issue spotting is, now it's time to start writing out the answer. Now let me tell you how students will typically do this. Typically you'll write out an entire answer to a practice essay for, let's say, an hour, hour and a half or more. And then at the end, right, maybe you've written out 10 different issues. Then you're going to look through the sample answer. By that time, typically students are not doing a thorough look through that sample answer or cut sheet just because they're a little burnt out of doing the essay. They might then just be hyper focusing on an issue or two that they were really curious about. Like, oh man, like that one issue really stumped me, and all of a sudden that becomes their focus. And so now other issues weren't studied as much for their sample answer. So what we're going to do is pretty much piecemeal this out to make sure we're learning on what we could do for each issue. So let's walk through this and see what the system is. When you are provided a sample answer, here's your step. The key is to refer to the sample answer while you are writing out your answer instead of waiting to the end. So what you're going to do is put your heading. So let's say you put your heading for duty, right? Then what you're going to do is go and grab your rule. During practice essays, this is not the time to focus on memorization. We've talked about this before. Right now, I want to see if you can properly analyze when you have both the rule and the facts in front of you. Once we can do well with that, then we can start focusing on memorization. So you go and grab your rule. So now you have your heading, you have your rule, and obviously you have your fact pattern. Now you see it's time to shoot your shot. Give it your best shot at analyzing with what you have. Use the facts, don't be conclusory, make those good arguments, consider any counter arguments, then conclude. Now again, this is where naturally a student would just go on to the next issue and start analyzing again. But what I want you to do is compare. So you just wrote out the duty analysis. I want you to now go to the sample answer and see how did I do with that. All right. It says I want you to immediately compare your work product for this issue to the sample answer. Take mental or physical note of everything you missed. And here are the things that I want you to look out for. Clever arguments you missed that you can recycle and use later. Better and cleaner rule statements that you can replace your current rule with. Facts that were important for this issue that you missed. Compare the length of discussion. If your discussion was 2 sentences and the sample answer was 7, all right, I didn't spend enough time here. Maybe this was a prioritized issue and I didn't realize it. And then see if you missed any counter arguments. As we've learned, you don't do counter arguments for every single analysis, and it's a judgment call as to when you should. So if you missed a counter argument, kind of figure out why was there a counter argument here, and then take note of it. All right. And so once you've gone through that comparison process for that analysis and you soaked it all up for duty, now you can move on to the next element, breach, and repeat that process. Put your heading, grab your rule for breach, shoot your shot, and then compare. And this goes not just for negligence, but every single practice essay for every single class. You want to go through one issue at a time and learn for each analysis. Okay, so that's when you are provided a sample answer. Now, unfortunately, we don't always get sample answers from our professors for every practice essay that we do. So here's what you do when you don't have one. If you don't have a sample answer or a cut sheet or any resource to see how you did, then you have to find a way to get feedback, okay? Here are some options. Go to your office hours and ask for review. Submit for review if your professor offers that, or ask a TA to review. There's also third parties and supplements. There's companies like Legally Fit. We have tutors that can look over your essay and things like that. So there's also third party options as well, but you should have a lot of on-campus resources for something like this. Pro tip, you must be resourceful here. Don't be the student in a class where the professor doesn't have any sample answers and then just decide I'm never going to get any feedback. All right, the students that go that extra mile to figure out if they're doing that correctly are going to be the students that perform better. All right, now that is the situation when you are not provided with a sample answer. Let's now talk about what happens when you maybe have a lot of practice versus not so much practice from your professor. So first is the scenario when your professor gives you a ton of practice essays to do. So it says here, for professors that give you at least 15 practice essays, you may not be able to write out all of them. So I'm going to provide you with some alternative ways to go through practice exams so you can still do all the ones that they've given you. So traditional practice mode is what we just went through and talked about, where you're detailing, each issue and going through it, comparing it, etc., writing it out, right? All that jazz. Read and think mode is you do not write out any of the issues. You're only thinking through your arguments and then comparing to the sample answer one issue or topic at a time. So it's a very similar process. You're just skipping out the writing, but you're actually taking the time to think through it. Here's what I would say, and then you compare. All right. Don't get cheeky now, too. I know some of you thinking, well, I could just do that for all of them. You want to practice typing things out. You have to practice as though it's the game, right? To get that muscle memory for what that experience is. And I promise you, you want to write exams out. All right. And then next is hybrid mode. So hybrid mode is essentially a hybrid between the traditional write everything out and the read and think, which is write nothing out. So in hybrid mode, you can hand pick out of an essay which ones you want to write and which ones you're just going to read and think through. All right, so pretty straightforward there. All right, so those are the different ways to go through practice essays, again, especially when you have a lot of them to do. If you have a professor who's only giving you 4 practice essays, I want you to write all of those out in the traditional method. Actually write those out. Again, if you have now a ton of essays, you can't write them all out, then now here are your options. All right, so what do you do when your professor doesn't give you many practice essays? We all have that professor, right? That's just like, I don't have any for you, or maybe you only have 1 or 2. All right, so this does not mean you get a pass on doing practice questions. You still must practice, and again, you have to be resourceful. Find alternatives, and here are your options. You can use supplements that provide essays and sample answers. Legally Fit is a great one. There's bar websites that have bar essays and sample answers you can look at. There are things out there to give you exposure to these common test patterns, right? And then another thing that you can use is another professor at your school. So maybe you're in section A, right? And you have Professor A for contracts. He doesn't give you any practice essays, but Professor B, who also teaches contracts at your school, happens to. Well, go ahead and use that. At that point, if it's not your professor, whether it's a Legally Fit essay or Professor B, it's really now just like anything you can get your hands on is going to be something good. So those would be essentially weighted equally. It's going to come down to, right, which resource has an emphasis on giving you sample answers so you can really learn from it. You don't want to do a practice essay for a supplement or another professor and they don't give you a sample answer because, again, you're kind of doing it with one hand tied behind your back. Okay, so that's what you do when you don't have many practice essays to do. And this is the last step when doing practice essays. And it's the most important. You see the big exclamation, the warning sign. You have to take notes. Reflect on everything you've learned, everything you've missed, and everything you've gotten right. What's so difficult for a lot of us in life, in law school sometimes, is to kind of like sit in our mistakes, sit in what went wrong. And actually sometimes, it's crazy, but like find enjoyment in that process. Like, dang, like, why did I get this wrong? Like, how did this trip me up? And enjoy that process. So that's what you want to do, right? A lot of times students, they go through a practice essay like, oh, they didn't do that well. You want to just move on to the next one that then you can do well on so you can feel good, right? So we want to avoid that kind of urge to do that and sit with everything that, again, went well, wrong, etc. Create templates for certain issues, rules, and attack plans for certain fact scenarios. So, again, we were talking with Nathan about torts, right? And then he may realize, okay, so I'm noticing that every single time I do negligence, I go through the 4 elements in the same order: duty, breach, causation, damages. It doesn't change based off of what the prioritized issue is. So now I have a template for going through negligence. These are the 4 elements, and here's the order that I go through them in. Now, you could have another area of law that maybe doesn't have a fixed template, and there might be a few variations as to how you go through it. But the idea is that as you go through practice essays, soak up that information to see how it's done before. And this is just all on the principle that most 1Ls don't realize that these final exams aren't so much about creativity in any way. It's, have you seen this before, and how was it organized before? Have you seen a scenario like this, and what was the outcome in that scenario, or what were the arguments made? It's all about pulling from what you've seen before and articulating that cohesively based off of that current scenario. All right, so those are like the idea of templates. Also take notes on trends and patterns when comparing to other essays you've done. For example, in torts, you might notice that man, whenever I talk about assault, I see that battery is always triggered as well. Now all of a sudden you're seeing that trend and that pattern. You'll keep that in mind when you get to your exam. And then the last thing that I want you to take notes on is updating your outline after every practice essay. All right, so what are some of the things you can do with your outline? You can identify triggering facts for issues you didn't get and insert them into your outline. So with that example we did with Deja, let's say she had outlined easements and she missed that. So she would put in, oh, when one person is using a person's house, such as parking in their driveway for an extended period of time, and they want to continue to do so, that triggers easement. You can literally just put that into your outline so you can start to accumulate these things that you missed, and that way you don't forget them later. You can identify rules that were better than the ones you had and update your outline with now this better rule that you saw in the sample answer. You can identify a better order of operation. So if you see there's a certain way to go about analyzing something, you can change your outline to reflect that so you're learning in a consistent manner. And then you can also put in clever arguments, right? A good law student is remembering those good, clever arguments and then not coming up with their own creative one on the spot. If they've already seen something that was good and worked, they're reusing that. So that is like one of your hacks, that as you're going through practice essays, to store as many of those. So on the exam, you can have a lot of stuff just ready to fire off, right? And then save time for then the curveballs where you do have to slow down and think. All right, taking notes. This is the step that few take. This is also the step that high-performing students do take. So don't forget, don't just move on after you finish. Take a second, reflect, and take all these notes. All right, and our last slide for today is talking about then the exam, right? Everything we've been talking about is practice, but I want to make this note. The steps are similar when you are then taking your final exam. The biggest difference is that you will not be able to cross-reference your outline or your analysis as you go, and you'll be ready to pull your rules from memory instead of the outline. Studying and practicing in a way that is consistent with how you will take the exam is what creates comfort. Follow this approach and you'll have a consistent feel to your process of doing these questions, thus making the exam feel very similar to doing questions in the comfort of your own study room. So again, I'm not making this stuff up. You want to practice the way you're going to perform, right? And so what you'll be doing here is creating that system that's like, all right, once it comes to the day of the exam, I know what to do. I know how to do it. All right. Don't forget, we have a ton of resources on the website. Master the subject. We now have crash courses becoming available online. So go on there if you need any assistance with understanding the substantive law. We got your back. And that concludes today's session on how to do practice essays. All right, thank you for joining the 1L Club on practice exams. The key takeaway today was, remember that practice exams are for practice. Do not wait to get started, and make sure you get in there, slow down, and soak up all the many lessons and ways that you can improve. Wishing you the best of luck with those practice essays. And do not forget to subscribe to our channel and turn on those notifications for more 1L Club events. Learn more about Legally Fit and Break into Law School in the description.